Okay,
Do you want me to just
I want to
one share?
introduce you.
Oh, that's
Hello, everybody. Welcome to our webinar, and I want to introduce Rick Porter to you all. He is the program coordinator. He is now over dispute resolution at the department. Okay, we are no longer the Department of Education, and that is so hard for me after 35 years. We are now the Division of Elementary and Secondary Education. So from the Center of the Exceptional Families, we are so excited to have Rick with us today. This is a subject that a lot of people don't understand, is dispute resolution. I think a lot of people are confused between what is mediation, what is a due process hearing, what is a complaint. So today, hopefully, you can help us clear all of that up. Your chat box is open. So if you have a question for Rick, if you'll just type that in the chat, you can handle that any way you want to, Rick. If you want to, if some of them can work in, or if you want to handle them at the end, because your presentation may actually cover some of the questions. So
yeah.
however you want to do that. Okay.
Okay. No, that's fine. That's fine. I'm easy. I will keep this little chat box open, and if you um have something you just want to put in there, I will get to it. If it's going to come up further in the presentation, I'll hold, and then but we're all friends here. We can just talk. So, well, thank you for the invitation to be here. My name is Rick Porter, and I work in the dispute resolution office. And I've been here a little over a year with the Division of Elementary and Secondary Education. Prior to that, I was at the Arkansas School for the Deaf for 21 years. In the last 7 of those as the special education supervisor. So, a little bit about me. Um, and really, I like this particular work. People ask me, well, how can you do that and listen to angry parents on the phone and deal with that all day? I said, this is what being a special ed supervisor is about. The only difference is they're not mad at me now. They're mad at somebody else. So this is a piece of cake. And I say that in jest, but seriously, we do try to work with families and with schools, and that's a big piece of what I'll be talking about today as well, is um, just that collaborative piece of the schools and the families working together, all for the best interest of the child. So with that, I'm gonna click. Is this gonna go, or can I? There we go. So quick disclaimer, this information I'm providing is the best that I know today. It may change at any time, especially in this era of COVID. There's new guidance that comes out at random times. So what I'm telling you today may be nuanced different, or it may be radically different, or it may be affirmed. We just don't know. And this is general information on special education. And if you have specific questions regarding local matters, please consult your attorney. And I actually pulled a lot of these slides out of the training that I do for schools. And the reason is because I want you guys to see what we're trying to communicate to schools and what we're trying to get the schools to understand in working with families. And this is something that I really had to rethink, and I kind of had one of those aha moments about 5 years into being a special education supervisor, is there are many different paths that can lead to the very same goal. And the thing that I want you to understand as parents, and I want the schools to understand as providers, is that everybody around that table almost without exception, they want the exact same thing. They want the best for this young person, for this student to be as successful as they can be and to have the most positive outcome possible. Now, how you get to that point, that's where the rub comes because there's many different views and perspectives. But if you will think about this and consider this as you're going through some of those more pointed and difficult conversations, as you're making decisions, it will kind of help. You may even want to start the meeting and have this. I've even done this as well and put a picture of the student in the middle of the table before you start,
Mhm.
and then have this quick kind of starter before you start the conversation, especially if you're going to have some difficult discussions through this particular meeting.
Yeah.
So I encourage schools, and I put this slide in almost every presentation that I do with schools because they need to hear that as well. Another slide that I wanted to put in here, again, we're all critical members of the team and we all have a piece of the puzzle. And so when you all come together and you all bring your pieces and you all put them together, you get the very best picture and plan for this child moving forward because you as parents have insights into this child that they do not have. Now, granted, educationally, they have some insights that you don't have, or maybe they're service providers like a speech pathologist. They're going to have insights that the teachers don't have or that the parents. So it takes all of you together, at least in principle. And I get there's going to be differences of opinion at times. But if you go back to that first slide and you go back to an agreement that everybody here is for the benefit of that child, you can get through some of those difficult conversations. And through the special ed unit, if you haven't heard of this book, I encourage you to either buy this book or there's a light version that's a free download from the CEC website. It's called High Leverage Practices for Inclusive Classrooms. And it highlights 22 high leverage practices that are beneficial for students with special education and primarily to move towards an inclusive setting. But I've picked out these three because 2 and 3 are directly about communication and with the parents and collaboration with the parents in schools. So number 2 is leading effective meetings with professionals and families. And number 3 is collaborating with families to support student learning needs. And those, you can't be an effective team if you don't have those 2 pieces. And then number 10, if you notice, is highlighted. It's conducting functional behavior assessments to develop individualized behavior supports. And the reason it's highlighted is actually one of the 4 that the department is actually emphasizing to the schools this year. And we'll talk a little more about that in a bit, actually towards the end, but I just want to include that now. And really, if I can stress one thing to you guys, communication is critical. And so I'm gonna ask you guys this question. The number one way to reduce or prevent disputes between schools and families is what? I've kind of already told you, but
Communication.
authentic communication between schools and families. And I stress this in every single training I do, regardless of the topic, this is in there because this is where the rubber really does meet the road. And even if, oh, thank you, Shelby. I'm preaching. Let me get on my soapbox here. And, I can't stress enough to schools that, if you will, communicate with the families regularly And a story that I use with them, an analogy, is it's like going to the bank and putting money in a savings account. If you will communicate regularly before there are problems with this family, when there are problems, you have a trust and a relationship, and you have deposits that you can withdraw to help get you through that. But if you haven't made any deposits, you're not going to make a withdrawal. And again, there's responsibility on part of the parents to that piece as well. And I'm not trying to say that the school's all at fault, but probably 90% of the calls that I get in this office are related to or a result of poor or no communication. And so then what we do at that point is try to repair that communication breakdown and facilitate some appropriate communication to resolve the issue at hand. So I feel like Jerry Maguire, if you've seen that movie, and I tell schools this, and I tell my coworkers this. I said, I feel like Jerry Maguire because I'm trying to fix this particular situation and help the two sides come together before it becomes a formal dispute situation. And I'm like, help me help you. And I'll give you this. There was a complaint filed last year with the school, and we received a call. The SEA, which is the special education advisor that's assigned to that specific school, the parent reached out to that SEA, and the SEA reached out to the LEA supervisor and asked the LEA to call the parent. Well, she didn't. A week later, I received a call from that same parent. I talked to the SEA and I talked to the LEA, and I said, please call this parent. You know, we talked through some of the parents' pain points and kind of some ways to have that conversation with the LEA when she calls, because typically when I ask them to call, they call. And so then no phone call happened. Several days later, I got a call again in that LEA. Still hadn't called. I reached out to the LEA again. She has reassured me she would reach out to this parent. Never did. A week later, I get a state complaint in my office. Well, how can you blame the parent? She's tried to bridge that communication, and it just wasn't reciprocated, so she had no choice. And she prevailed, by the way. And so the school had some corrective actions that they had to deal with because of that. And it so easily could have been avoided with some basic communication. So with district communication, hey there. Sorry. So for district communication, here's something in black that I tell the schools when I do any dispute resolution training. So how often is the teacher engaged in authentic communication with the parents? You know, is it weekly? Is it every other week? Is it daily? And oftentimes teachers are so busy and they have so much responsibility, they don't have time to do daily communication. If there's a problem, sure, but just as a regular daily communication, that's really not realistic. Because if they've got 20 kids in class or 15 kids in a resource class, you know, that with all the paperwork and grading and planning that they have to do, it's really not feasible to reach out to 15 parents every day. But I would flip that and say, are the parents accessible? Because if the school's reaching out, are you available? And I've lived this, and you know, you go through every phone number that's in eSchool and there's not an answer. Well, and in fact, if you'll remember, we had one when I was at the school for the deaf. I had to reach out to the local school to have the local school send a resource officer to do a well child check just because we could not get a hold of this family. So On the same token, if they're trying to reach out, are you available to participate in this communication? Does the school of teacher, administrator, SPED designee, or LEA return calls in a timely manner? I've seen this all the time. I when parents are upset, they reach out to the school and it takes them a week to get a call back. And a lot of times, they reach out to the principal or assistant principal. And then I ask them, have you talked to the special ed supervisor or the building designee if that district has one? They often will say, no, I just talked to the principal. So I'm like, well, let's reach out to the special ed supervisor because one, they have the authority to affect the change that needs to happen in this situation. And two, they understand the special ed laws that are involved here. So let's include them in this conversation, and then they can communicate with the principal if that needs to be. So a lot of times that would be my response to the parents. And then, is there information on your school website that guides parents to the appropriate resources or contact person in special ed? And I've been on many of the school district websites, and you have to click, if it's more than 3 clicks away, they're not going to find it. And so, do you have the appropriate contact person for that school building for special education accessible to the parents so that they're not just talking to the principal? And again, I'm not trying to throw the principals under the bus because they got a huge responsibility in trying to run the entire school, not just be concerned about the special ed students. They got buses and cafeteria and PTA and the school superintendent and all these other things to worry about, in addition to the day-to-day operations of all these students and supervised teachers and everything else. They're busy. So, and again, I'm not trying to throw them under the bus, but at the same time, they don't always have availability to do that. So a lot of times the special ed person is the one to address that. And again, I'm not trying to be so deep into all this, but these are just some of the things that I really do talk to schools about regularly. And a reason for good communication financially is that a facilitated IEP is free to the parties, but it costs the state about $135. Mediation, again, is free, but it costs the state about $300. If you file a state complaint, majority of that cost comes to the state because we hire the investigators and write the report and do all that. But it typically costs around $4,000. And the cost of a due process hearing, if it goes all the way to the end and the district is found at fault, you're on the hook for both sets of attorney's fees plus the cost of the corrective actions, and it's about $85,000. So, communication can avoid so much of this. And this is my point. So I wanted to talk, before we get into the formal dispute resolution pieces, I want to talk about some of the implications of COVID, because that's been on everyone's mind. Just go ahead and let's talk about the elephant in the room.
Yeah.
So with dispute resolution, for as far as state complaints, there was never a lag. We immediately switched over to doing interviews by Zoom, and nothing was negatively impacted. Everything went just as intended. With due process hearings, the parties, the attorneys on both sides, they felt that they would rather, if possible, meet in person. And so initially there was a lag because they filed for continuances to put it off to see how long it would be before they could get back together and actually hold the meetings in person. So we had a kind of a lag build up. And when it was obvious that we were going to continue on in this pattern for a while, we started holding uh, virtual dispute due process hearings. Sorry. And so now we're at the point we have pretty well got that lump through the snake's belly. We're caught up and we're on track, and we've not missed any timelines because all of the continuances were party initiated, and so we're still legally okay. Um, this concept of compensatory education or compensatory services, as OSEP called it. It's been called recovery services and catch up services and unfinished learning services. That one's my favorite, by the way.
I hadn't heard that one.
Anyway, so when you talk about that, it's very complex. And very few cases have made it through the courts at this point, but there have been a couple of court cases that address and due process hearings at the state level that have addressed this issue. And they typically apply a case that's called the Dyne Test, VANDYUN. And what that is, that was a Ninth Circuit case out in the West Coast. And basically, they claimed that the failure to implement the IEP has to be material, is the word. And what they mean by material is substantial. So if there was a substantial failure to implement the IEP, that resulted in a denial of FAPE and a lack of progress, then compensatory services are appropriate. And so far, what we've seen is they've not been a minute for minute replacement. It's been a best estimate based on the progress made and the amount of services that were missed. So it was not intended, but let me birdwalk just a second. IDEA was not written with a national pandemic in mind.
Yeah,
So
exactly.
please understand that we're in uncharted waters. You know, the law that we're following wasn't intended for this situation. So even the brightest legal minds are making guesses because no one really knows. But with that being said, schools still are responsible for all of the provisions under IDEA regarding IEPs and a provision of FAPE. And another thing that we talked about is the remote learning plan. And we put out guidance back right before school started on remote learning plans. They're optional, they're not required. And the remote learning plan basically is to be used in lieu of an amended IEP, so that should the child have to go from in-person instruction to remote because of a probable close contact or some other situation, that the services are already planned and agreed upon, and then you just roll, you're ready. It's already mapped out. There's no sitting and waiting and trying to figure out what are we going to do.
Right.
So that's the intention behind. Now, you can still amend IEPs and do it that way. You can have a formal IEP meeting and do it that way as well. But any change in the IEP, the one thing that they have said from OSEP is that the parents are required to be given a prior written notice anytime the IEP is changed. So if you're changing the provision of services, whether it's through an amendment process or whether it's through a remote learning plan or whether it's through actually holding an IEP meeting and changing the IEP, the parents are still entitled to that prior written notice for that change. And so in Arkansas, this is all brand new. Within the last month, we've actually had 5 state complaints, and all 5 are COVID related. And we do anticipate nationally, as well as within Arkansas, an increase of due process hearings, as well as OCR complaints. And those issues center around 3 main topics: IEP implementation or failure to implement, access, and access is actually 2 different things. So there's the actual technology piece of access with the hotspot and the laptop or tablet or whatever technologies involved, but there's also the access piece of the child behaviorally, emotionally, academically able to participate and access the instruction that's provided. So there's 2 different prongs of access that mean very different things. And then equity is another issue, and that refers to what services are being provided for students in general education as compared to students in special education. Are those services equal, equitable, appropriate? So an example of that would be if you have remote learning for general ed students, then you have to make an option of remote learning available to students with special education. And related to that, for students that aren't engaging, there's the Engage Arkansas initiative that came out, and schools can opt into that, or families on their own can opt into that without the school, which is a very nice piece. But districts can, because of that, or failure to progress, require a student to come back to the district. Now, they have to be careful and they need to make sure that they have data to support that decision, because they're likely to have to defend themselves if they do. But that is an option. And I just wanted you guys to be aware that that guidance has been put out there, because engagement has been a really, really difficult, but it's not a SPED specific issue. It's just a statewide issue.
Right.
And then the other provision that we're concerned about is this premise of stay put. And what they mean by that is students who have changed from in-person instruction to a remote setting and not being provided special ed services, some attorneys are challenging that that's actually a change of placement. We have, as well as states across the country, have opined that if you change from in-person to remote, you're changing the modality of the instruction. As long as you're providing those services, then you haven't changed the placement. And there's been some court cases, and we'll talk about those in just a minute, that have kind of touched on this. So in New York, there was a case where they provided technology and this specialized program, software program for all students in their special ed program. They went to court, or actually as a due process hearing, and they lost because that word all, they didn't individualize, they didn't consider what this student needed for their provision of FAPE, and they have to provide in-person instruction as safely as possible, as long as it meets the state health guidelines. And in New York City, I'm not sure in July how that was really going to work. But another case in Guam, parents filed a class action suit for a stay put injunction because they're challenging that the remote services were, in fact, a change of placement. They failed to prove that it was a change of placement. They failed to prove that the remote learning was going to cause harm to the student, and they failed to prove that the remote learning was not satisfactory. So they did not get that injunction. New Mexico, this is an interesting one. It was a class action suit, and it just happened. Let's see my computer, 10/14. So that was what, 2 weeks ago, 3 weeks ago? So essentially, it was a class action suit, and the same thing. They were arguing about in-person instruction versus remote, and they threw out the entire case except for one portion. They found that this one particular child was not progressing using the remote instruction in the school because of the way their reentry plan was written, was not equitable, and so they were required to provide in-person instruction within the guidelines of the state's health requirements. So the majority of it was thrown out. This one particular student was able to demonstrate that they were, in fact, denied FAPE and won. So, with all that said, any questions regarding the COVID, the cases? I was going to tell you also, have you guys seen this? This is actually a article written by Perry Zerkel and Natalie Jones, and it's, I believe, on the Cadre website. And it's basically a 6-month snapshot of all of the due process hearings, court cases, and state complaints. They did a survey, and I participated, and they sent it out to all 50 states. And only 4 states didn't respond. So it's a very good representation of kind of what the states are dealing with in the first 6 months. At that point, we had not had any. So since then, we've had 5 state complaints filed that were COVID related. But no. So anyway, if you're interested and like to geek out in that stuff, I believe it's on the Cadre website, and you can look that up. So dispute resolution processes. There's actually 4 formal and 1 informal. And the informal is essentially a phone call or an email. And so when a parent calls, we will kind of listen to their concerns. We will identify their pain points. Then we will kind of see where they are and all of that. Then we will see if we can reach out to the school and try to facilitate some conversations to address those pain points that we've identified. And more times than not, that fixes it. A lot of times, a school, we call a school and they're, oh God, Rick's calling. Oh God. But that's really not the intent. The intent is to get the 2 parties together to come to an agreement for the benefit of that student. That's the goal. And 90% of the time, I would say that solves it. But if it doesn't, then we have these 4 formal processes. And if you see that line that's going up and down on the side, the reason that arrow is there is because this is the order that I described them to the parents, because that's the amount of time increasingly that they take. It's also the complexity of the process involved. So we start with that because it's the fastest way to get the parties together for the benefit of the student. So a facilitated IEP meeting, mediation, state complaint, due process hearing. Those are the 4 formal processes. So the next several slides are going to be about those. So I'm going to go ahead and move forward. So we'll start with facilitated IEP meeting. Okay, the facilitated IEP meeting and mediation from the naked eye look very much alike. They're done through the Bowen School of Law. A person will be there to run the meeting. They will have talked to the parties to get their concerns and make sure the appropriate people are at the table. In a facilitated IEP meeting, the facilitator doesn't write the agreement. It's on school special ed paperwork, the IEP, and notice of action. Facilitation allows, just like any IEP meeting, for attorneys to be present, and it's voluntary. You can't, if one party says no, then it's not happening. Both parties have to agree. Bowen School of Law does also ask the parties to sign a confidentiality agreement because they want both sides to feel this is a protected environment where they can speak openly and honestly to deal with the issues at hand and come to some sort of agreement. As where mediation is actually written in our regulations, and we're monitored federally on mediations, not on facilitated IEPs. But the purpose is, and it's in section 10 of the regulations, is right up at the top, to resolve, if possible, all disagreement. If you can't resolve all of them, to narrow the range down to a single or as few points as possible, and to provide an atmosphere where you can have those relevant discussions to hopefully come to an agreement. And it is, again, voluntary, and it's not used to delay or deny a parent's right to due process. So basically what that means is you can file a mediation and you can file a state complaint the same day. And so they're not exclusive where you have to go through one before the other. Now, I would encourage you, if you are already in the process of mediation, a day or two typically is not going to hurt. Go ahead and go through the mediation, see if you can work it out. If not, absolutely file the complaint and we will investigate it. But, it seems kind of silly to go through the filling all this out if there's a real chance of working it out. The facilitator actually writes an MOU, which is a written, legally binding contract that can be enforced in any court of competent jurisdiction. And it too is confidential. And so they don't want you outside talking about it. And I tell teachers and LEA supervisors, tell your teachers to zip it, because if they're chatting about it down the hallway, that's not good. And with mediation, unlike facilitated IEPs, attorneys are not allowed because typically attorneys amp everybody up. I know my hair always stands up on the back of my neck when attorneys are in the room. And so this environment is to bring everybody down and together. So they don't want attorneys in the room. But a facilitated IEP, you can. So everybody clear on the differences between the facilitated IEP and mediation? I don't see anything in the chat, so we'll move on. If you have something, let me know. And so the coordinator for the special education mediation project at the Bowen School is Tiffany Tackett-Kell. And this is her phone number. And if you have need of this, reach out to Tiffany. She's super and would be glad to help you. Okay, on to state complaints. So Section 12 of our regulations is all about state complaints. And so remember, we talked about the arrow going down. As you see now, the timeline is 60 days to complete a state complaint. And it takes 60 days because by the time we get the complaint, then I will have a phone call with you or whoever files it. And then I will make sure that I'm capturing the issues that you have put down. Then I will take those and match them to specific regulations that we will investigate. Then We assign a team, and the team will then reach out to the parties, the parent, and they'll request any documentation the parent has. They will schedule a time to interview. They will request documentation from the school. They will schedule all the relevant people at the district. And then they will bring all that back. They'll write a report to basically tell the entire investigative process and if there was evidence to substantiate the complaint. The district does have an opportunity to respond to the complaint, including a proposal to resolve the complaint or to ask for mediation to come to a resolution. So a state complaint must include these 7 things. It must be in writing. It must be signed. It must include a statement that the agency has violated a requirement of law. Include the facts around what happened. Tell me. It must allege that a violation occurred within 1 year. So the date you file it, it goes back 1 calendar year. So today is the 5th. It would go back to November 6th of 2019. And it has to include a resolution, a proposed resolution. What do you want the school to do to fix it? You can't just complain and not tell me what you need. And then it also have to forward it to the public agency, the school, at the same time. And this is a little tricky because this actually happened last year. So we had a parent send in a complaint the last day before Christmas break. And they sent it to us, but they didn't send it to school. And by the time I got it, opened it, reached out to the school, they were gone for the break. They all snuck out early. So I couldn't reach out to the school. So when they first showed back up after Christmas break, I called them. They're like, we didn't know anything about it. So their timeline didn't start until January when they were notified. So I can't start the timeline on the 60 days until the school is notified. And so again, it's 60 days. So then we write the report and then we send it over and Secretary Key actually signs the report. And then it goes out to the school and to the parent. And they explain exactly what they did and how they arrived at the decision. And if their allegations are substantiated, any corrective actions that are required. And speaking of corrective actions, I've had parents that really want to crack the whip and punish that school. That's not the purpose. If a school is found to have violated a regulation, they are given corrective actions. And the goal of that corrective action is to support the school to bring the school back into compliance and providing support and services to the student within the guidelines of IDEA. Some examples of corrective actions can be training for the district, reviewing or amending a district policy. And we've had that happen. Basically, a district, I'll just give you an example. A district had a very odd mental health policy and they weren't following it. So they were required to go back and review. Not all the team members were aware that there was a policy. So they had to go back, review and revise the mental health policy so that everybody's on the same page.
Rick,
Go ahead.
I've been asked before, just kind of one slide back, when the report is being written, who is present and what does that look like? Does everybody sit at a table together and pull out law books or the regs, and is that discussed openly? So can you kind of tell us what the report writing looks like?
Yeah. So what happens is the investigative team.
And can you kind of tell us who's on the team?
Well, the team will be 2 to 5 members.
Good.
is what it says. Typically, it's 2, sometimes 3, depending on the nature of the specific complaint. They will do the investigation. When they come back, they take their notes, they take the written documentation, and they take the allegations, and they go through the interviews, they go through the written documentation, they go through the regulations and or the scope, whatever documentation they're needing to go through, and then they make a determination on if that is in fact a violation.
Mhm.
And then they write it all out. And if they have specific questions, they will come see me. I'm not on the team, but I will then come in and help them answer those specific questions. If I'm not 100% sure, then we bring in somebody from our legal department to help us as well. But it's usually just the team. They're the ones that do it. It's their investigation. So it's not like it's open here in the office and everybody jumps in. It's the team.
Good, good. Thank
So
you for
then, yeah, so then the team, once the team is done and they have a report, then I will come in and we will do a read together.
clarifying.
And basically, what I'm doing at that point is making sure that kind of a double security check to make sure that the allegations, the evidence is there to support those allegations if they're found one way or the other. And then we review the actual writing and look at make sure it flows, make sure it's technically correct, make sure that all of the appropriate documentation is noted. And then once that is done, then, if it may take a couple of rewrite, edit suggestions, that kind of stuff. But once that's done, then I submit it to Matt Sewell, the director of special education. He's actually the director of special programs now, but he also is my boss. And he gives it a read. And if there's any issues, then we'll talk that through. But once he says good, then it goes to Secretary Key. And then Secretary Key reads it and he signs it and it comes back. Then the team lead signs it and then it goes to the schools and the parent.
Thank you. That's a great breakdown of the
Okay.
process. I appreciate you doing that because you very smoothly went over that, which is what we need. But I think parents and the school too need to understand that it really is a tedious
Oh, yeah.
process, that you all put so much work into it. And it's well thought out, and there are many sets of eyes on
Yeah.
this.
Yeah. And then when I said it costs $4,000, there's a lot of man hours that goes into
Mhm,
those.
mhm. But when people are really good at their job, it looks easy, and that's a compliment. It really is. But sometimes I think it's really important to break it down
Yeah.
so
Yeah. I
we
mean,
can
it's
see.
a very involved process. So
Mhm.
again, that's just in a quick 5-minute thing. That's the process. And unfortunately, there's no appeals process in Arkansas. But if you still disagree, you do have the option to file a due process hearing. But if you file a due process hearing and then later file a state complaint, I can only investigate back to the point that that was filed because that is adjudicated and it is hierarchical. It beats a state complaint. And if you have a state complaint that's already been filed and then you file a due process, those same issues, then I have to hold the state complaint in what's called abeyance. And I just set it aside until the hearing is completed. And whatever the hearing officer decides, we'll decide that. Now, if there are separate issues as well, we will continue to investigate those separate issues. But the issues that are addressed in the due process hearing, we can't touch. So just another little add-on to that.
That's
And
good
so
information.
we're on to due process hearings now. And so with the due process hearing, it deals with filing, basically it's court. It files a complaint on matters outlined in IDA, and it's 4 areas. It's the identification, evaluation, educational placement, or provision of FAPE, free appropriate public education. And as where state complaints are very kind of procedural focused, due process hearings are substantive. And so if you go back to Rowley, that's the test. So there's the 2 components. There's a procedural requirement and the substantive piece. And once you theoretically can have procedural errors as long as it didn't deny the substance of the free appropriate public education. They typically say that procedural violation was harmless. So they're looking strictly at this, as where state complaints can look at this as well, but their primary focus is the procedural component. So that's just another little nuance of a difference in what they actually look at. So here's a quick timeline, and I know it's a little fuzzy, but on the actual PowerPoint, it's clear. And if you'll look at that bottom line that has the maize, the maroon and green, that's the line I want to look at. And so if you look at that first 15 days in gold, that's actually where the LEA has to have a resolution meeting or offer a resolution meeting. The parent doesn't have to participate, but you have to offer it. The next in the maroon is the resolution periods, because sometimes you have the meeting, and of course, if you filed a due process hearing, there's tension in the air. So you may not come to an agreement that day, but maybe you agree on some principles and need to work out the rest of it. You still have that other 15 days to get it worked out. If you do not get it worked out, on day 31, it starts your 45-day timeline for the actual hearing. So the hearing timeline doesn't even start until you get through this 30-day resolution period. And then once you hit that 31 days, that starts the timeline for the actual hearing. And so you're supposed to have the hearing and have the decision rendered in that 45 days, or a total of 75 days. And what often happens, and I try to warn parents, is 99% of the time in that green period, once you get to the actual hearing timeline, one of the parties is going to want a continuance. And they will write a motion to the hearing officer for a continuance, and they typically do grant them. So then it'll go out months and months, up to, it could be just a few weeks, but typically it's a couple months. But by the time they get together and get it done. So just fair warning, it takes a while. And again, as you go down that's why it's listed last, because 1, it's the most complex, and 2, it takes the longest. And to be perfectly honest, it often pits the parent in a very adversarial position from the school district. And again, you're going to have a relationship with that school for the rest of the time this child's in school. I know most people don't want to have an adversarial relationship with the school. And I know most schools don't want to have an adversarial relationship with the parent. So I always try to just make sure that in full disclosure, kind of where we're at. And again, it's not to discourage or deny a parent's right. I just want them going in fully aware of what they're actually getting into. And so when I talked about that first 30 days, a written settlement agreement is kind of the goal. And basically a written settlement agreement is just that. It's a contract. The school's going to do this. The parents agree to that. And it's a contract that's enforceable in any state court of jurisdiction or in a federal court. And so when we talk about trends, I just wanted to tell you behavior since I've been here at the department, behavior has been number one. In fact, I've got some numbers. About 40+% of the phone calls I get to this office, and I've been counting them, are around behavior. Last year, it was 41%, I believe, of all state complaints for the school year last year involved behavior, and over 40% of the due process hearings included behavior as well. So behavior is number one. That's the top issue. And because behavior is the top issue, I wanted to go ahead and mention a manifestation determination review. So if you've not been aware of this, basically a manifestation determination is something that is done when a school district is proposing to discipline a child to the point that it results in a change of placement. And a change of placement, by definition, is a removal of their education from school for over 10 days, or a series of removals that can be over 10 days, or a pattern of removals that constitute triggering of an MDR. It doesn't necessarily have to be over 10 days. If you've suddenly got a rash of behaviors and removals out of the blue, you may want to hold a manifestation. And what a manifestation determination review does is it looks at the child's disability and it looks at the behavior, and it tries to see if there's an actual connection where the behavior is actually caused by the disability. And if the behavior is caused by the disability, then you're required to do an FBA and the behavior intervention plan, or revise a behavior intervention plan so that you can support this student. If it is not a manifestation of this child's disability, if the behavior is not caused by, as the team determines, then they're subject to the same disciplinary policy as any student. However, if they are special education and the team determines that it was not a manifestation and they're going to remove the student for more than those 10 days, the school still has to provide their provision of special education services. And if you, as a parent, disagree with the team's decision of it not being a manifestation, you have the right to file a due process hearing. That's the standard. If you disagree, you file a due process. And you can file without an attorney, or you can there are several out there. And if you get to this point and you're not sure, call me. We can have a conversation. And then when we talked about that earlier, that functional behavior assessment is one of the high leverage practices. It's actually here. I've got it because it connected with the manifestation. So a functional behavior assessment is an evaluation and it requires parent consent. And it again is one of those high leverage practices. And the purpose is to identify the ABCs of behavior. And if you're not sure what the ABCs are, just a real quick, the A is antecedent. And that looks at the time of day, who's around at that point, what class is it? What's the temperature in the room? How was the child feeling that day? All of that goes into the antecedent piece. Behavior. B is behavior. And what that looks at is the actual observable actions of the student. And so many times when I was at the school for the deaf, I would get behavior documents and it would say, he was insubordinate, or he was mad, or he was angry. Those are feelings. You can't measure that. What did you see him do? What did you hear him do? Did he hit, kick, throw, bite, spit? Those are behaviors. So understand the behavior is something that multiple people can see and agree on. That's a behavior. And then consequence is the third. So your consequence, and I like to tell this story. So I was a brand new LA supervisor, and we were getting ready to do an FBA on a student, and we pulled out this behavior document. It was the newest behavior document for this student. And he was in math class, and he took a pencil and threw it right up at the front, right, just almost hit the teacher. So the student was then cheered by classmates and praised, and then the teacher got all red-faced and walked over and gently grabbed him by his arm and escorted him out to where he could go to the office, and he got D-Hall. So what was his consequence?
It could have been a reward.
It was. His consequence.
He didn't want to do math.
Well, there's that piece, but even also, he got praise from those students and acceptance from those students. So he was reinforced for that as a consequence. It didn't matter what punishment this teacher gave him, that wasn't a consequence, because the consequence already happened. He avoided the math he didn't want to do, because I will tell you, students, and I'm kind of getting off in the weeds here, but students who are being asked to do something academically that they don't have the skill to do, they will do anything behavior-wise is better than showing their friends that they don't have the skill set to perform academically. So anyway, so once you do that, you identify your ABCs, you identify the relationship between the environment and those target behaviors. You identify the communicative intent of those behaviors, because behavior is communication. Let me say that one more time. Behavior is communication. Then you have the framework to build your behavior intervention plan to reduce those behaviors. So anyway, that's the purpose of the FBA. And also, before on the FBA, it does not have to be a BCBA or a behavior or BSS person to do the FBA. I did them along with my school counselor, who was great, and our dean of students. We poured over that stuff, and our school psych. The four of us together, we did a bunch of FBAs, and I would put them up against any that were done by a behavior specialist.
I'm so glad you said that.
But, and a lot of times, and especially like in these due process hearings, if you read on our website, they're listed on there. They request BCBAs to conduct FBAs, and though they're fabulous, you don't have to have them. There aren't enough BCBAs to go around.
Right.
Now, if you have questions, you can call the co-op. They have a BSS person at each co-op, and they can help you to make sure you're on track to complete that appropriately. And if you need help with the behavior plan, they can help you with that as well. So anyway, sorry, off on my tangent. I wanted to quickly, and I know we're about at it, we're over time a couple minutes, but ACC, Arkansas Collaborative Consultant Resources. This page links all of their web pages, and that includes like EARS, ESVI for visual impairment and blindness, CASey for dual sensory impairment, Easter Seals for AT evals, TBI. Amy Goddard is doing fabulous stuff with traumatic brain injury. Transition services, Bonnie Boaz, she's phenomenal. She's been doing the inclusive movies with Joey Travolta, John Travolta's older brother. It's fabulous. Let's see, I always forget somebody. Co-teaching. They have worlds of resources.
They do.
Anyway, so reach out to them, even as an advocate, pick their brain. They will help. They will step in if you're got a situation with a school and jump in and be a thought partner with you guys. They're also available through circuit referral. So if you're having issues, and you don't have to be a school to do a circuit referral. Oh, so did I miss any? Anyway, I always miss somebody with the collaborative consultants, and it's not intentional, and it's always somebody different. So sorry if I missed anybody in advance. And there are other offices to address concerns, such as the Office of Equity Assistance, and they deal with 504s. They're just like our office, and they deal with 504s, but they also, more than that, deal with bullying and discrimination and any of those other OCR type concerns. And Oliver Dillingham is the director in that office. OCR is the federal level, and here I believe Dallas is our regional office. And they do, if you feel you've experienced discrimination, you can call them. If you feel that a child has actually been abused or anything related to that, you can call DHS. And then I want to add for the parents, yeah, I've got a few comments coming in the chat, and I'll get to those in just a second. But on the child maltreatment, please understand that teachers are not trying to pick on parents. They are mandated reporters. And so if they suspect an issue, they're not even to investigate that issue to determine. They suspect, they call. That's what they're required to do. And if they don't, they can be prosecuted. And so it's not that they've got something against the parent or they're trying to take advantage of a situation against the parent. They're required by law to, if they observe something, call. So I just wanted to put that out there. And then if you feel that a specific licensed educator has violated the code of ethics, we have the PLSB, which stands for Professional Licensure Standards Board, and they handle the teacher code of ethics. And so they do investigations against teachers that have potentially broken the code of ethics. And that's all I have as far as my slides. And there's my contact information. And I will make this PowerPoint available. I will send it over to Katie or to Shelby or Teresa. Hey, let me look at these comments real quick. Okay, well, sorry, Angie. And TCEF, well, TCEF is different. It's a parent information resource center. I guess it could, I mean, but the ACC's consultants are, they are all part of the SIP. I don't know if y'all are or not. That'll be a Jeff question. Shelby, we can talk about that. Yes, I'll include this PowerPoint, and if you go to the, if you go to the special ed website, those resources are all right there. Anyway, well, no other questions?
Well, I certainly appreciate you, Rick. I've known you, you've helped me over the years and so many kiddos, so many kids and families, and that's what it's all about. And
it is.
I think the key word communication, and it's miscommunication, because I think that so often it's just a misunderstanding, because again, we all want the same thing. We want what is appropriate and what's in the best interest of these kiddos, because we love them too.
Mm-hmm.
And I've gone to so many graduations and just absolutely sat with parents and boohooed, because they made it, and just such a good thing.
Yes,
And
ma'am.
so thank you so much for being with us.
Oh, it's
And
my pleasure.
and
And
we
if
wish
you,
you well.
well, thank you. And if you guys have questions later, once you see this, give me a call. I'll be glad to talk through any points that you have.
Okay. Thank you very
All right.
much.
Thanks, guys. You have a good day.
Bye-bye.